related conduct and therefore cannot be enforced against anyone because it's unconstitutional, and in this case has not met the correct test for the correct standard, which is strict scrutiny. I hope that that is clear. If it is not clear to you how these standards apply to the free speech clause, then please send me an email and I can try to schedule a one-on-one discussion with you so that we can get that cleared up, because you will see these standards again. They will resurface in your final exam, so it's very important for you to understand what they mean and how they apply. Now, question 4. Let's see if I can expand this. Okay, question 4. Which of the following is not an exception to the double jeopardy protection doctrine? Now, this comes directly from your textbook about double jeopardy. And I can see from the book here that double jeopardy was discussed in chapter 2. And your book listed 4 exceptions under which double jeopardy protection would not apply. The first answer, choice A, is incorrect because the defense plea bargains over the prosecution's objection. That is an exception to which the double jeopardy protection doctrine will not apply. That is an exception. The question is asking you to identify which one is not an exception. Answer choice B, the court hearing the first offense lacks jurisdiction. That is an exception. It's listed as the 3rd exception in your book. If we jump to answer choice D, the defendant is responsible for the 2nd prosecution. That is listed as the 2nd exception in your book. Again, we're looking for the answer choice that is not an exception, and that would be answer choice C, the prevention of a 2nd prosecution for the same offense. In that case, double jeopardy protection will apply because you've learned from your readings and from the PowerPoints that I provided to you that double jeopardy prevents a defendant from being prosecuted from the same offense by the same sovereign. So answer choice C is correct. It is the only one out of the 4 options that is not an exception to the double jeopardy protection doctrine. Okay, question number 5. The elements of attempt are, this one, the correct answer is A, the specific intent to perform an act and obtain a result that, if achieved, would constitute a crime and an overt act in furtherance of the crime. Many of you selected answer choice C. And answer choice C is incorrect. However, if you all chose answer choice C, no, I believe that the confusion was answer choice D, the defendant. Okay, from my review, many of you chose answer choice C, and answer choice C is incorrect because you've learned from your readings that the intent alone is not enough to constitute the crime of attempt. You must have the specific intent, and that specific intent must be coupled with an overt act in furtherance of the crime. And we know this because from our earlier readings, we know that there must be mens rea, actus reus, and concurrence. There must be some sort of act or the failure to act when there's a specific relationship between the actor and the victim. We don't have that situation here. So for attempt, you must have the specific intent. And keep in mind that the specific intent is very important because attempt is a specific intent crime. And in a separate lecture, I'm going to explain the difference between specific intent crimes and general intent crimes. It's very important to know the difference between those because specific intent crimes, the defense of involuntary intoxication is available for specific intent crimes versus general intent crimes. But just for the purposes of this question here, it's important for you to know that attempt is a specific intent crime, and therefore the intent that's required to sustain a charge of attempt must be specific. A specific intent to perform an act and obtain a result. So the specific intent must be to perform an act and to obtain that specific result that, if achieved, would constitute a crime. And then, of course, an overt act in furtherance of the crime. We know that answer choice B is incorrect because merely the intent required by the crime he is attempting to commit, that obviously is not going to suffice because there's no actus reus there. Answer choice C, I've already explained to you that that is incorrect. The specific intent to perform an act and obtain a result that, if achieved, would constitute a crime. There's no actus reus there. And then the last choice, the intent required by the crime the defendant is attempting to commit, and an overt act in furtherance of the crime. Answer choice D is very tricky because it lists that the intent is there and the overt act in furtherance of the crime is there, but what's missing is the specific intent. The intent must be specifically tailored to committing the specific act and obtaining a specific result because attempt, unlike a general intent crime, is a specific intent crime. Therefore, the correct answer is A. Question number 6. Which of the following describes sufficient intent to convict a defendant of an attempted crime? Let's turn to our answer choices. Answer choice A reckless disregard of an obvious or high risk that a particular harmful result might occur from the conduct. Well, we know that that is incorrect because I've just explained to you that attempt is a specific intent crime. You must specifically intend to commit the act, the particular act, and you must specifically intend to commit that act with the hopes of achieving a specific result. Reckless disregard of an obvious or high risk, that is recklessness, not intent. It doesn't evidence intent. So we know that that answer is incorrect. If we go to answer choice C, the awareness by the defendant that he is acting in a prescribed way and that any attendant circumstances required by the crime are present. Awareness does not equal intent. So that answer choice is not correct. We know that attempt is a specific intent crime, so our answer choice is going to have some kind of intent. in the correct answer choice. So we go to answer choice D and we see the word intent. The intent to perform an act and obtain a result that, if achieved, would constitute a crime. Now, this question, I received a lot of feedback from students as well, because the definition for attempt, I believe attempt is covered in chapter 4 of your readings, but the definition for attempt in your book is very similar to that answer choice. So many of you chose that answer choice. And I've decided, after reviewing these midterm exams and after speaking with one of the students, like I said, who was bold enough to contact me and actually dispute this question, I decided to give credit to anyone who selected answer choice D, for the simple fact that that definition is very similar to the one in your book. But I do want to be clear that that answer is incorrect. And the reason I'm going to give the credit is because the book did not really go into an in-depth discussion of specific intent crimes versus general intent crimes. And attempt is a specific intent crime, and the intent that's required must be specific. If you look at the wording for answer choice D, it says the intent to perform an act, any act, and obtain a result that, if achieved, would constitute a crime. What's missing from that is the specific intent that's required, the intent to perform a specific act and obtain a result that, if achieved, would constitute a crime. Now, answer choice B does not have the word specific in the answer choice, but it's saying the intent required for the completed offense. So let's say the crime is attempted murder. You must have the intent to complete a murder in order to be charged with attempted murder, because attempted murder is a specific intent crime. But answer choice D now is just saying the intent to perform an act. So let's say I intended to push you. That's an act. But then as a result of my pushing you, you fall, you hit your head, and now you're dead. Is that, can I be charged with attempted murder in that instance? No, because I didn't have the specific intent that was required for the completed offense, which was murder. I just had the intent to perform an act, pushing you. And as a result of me pushing you, you died. So I hope it's clear here why answer choice D is wrong. It's wrong because it says the intent to perform an act, any old general act. There's nothing about specific intent in that answer, and that's what makes it incorrect. Although the word specific is not in answer choice B, the correct choice, it does say the intent required for the completed offense. So that's just another way of saying the specific intent required for the completed offense. The word specific is not in there, but it's specific in that it's saying the intent required for the completed offense versus the intent to perform an act, which could be any act. So that is why the correct answer choice is B and not D. But I will give credit to those of you who selected answer choice D, again, because at this stage, there was not a discussion from myself or in your book with respect to specific versus general intent crimes. Question number 7. An affirmative duty to act arises for all of the following defendants except. Now, we should know from the call of this question that this has to do with actus reus.